So, and what are all these counts, 9, 10, 11, and other? All of them have to do with disobedience of lawful order and splitting of contracts.
Gentlemen, we're almost out of time. So let's look at what is the implication of this judgment. What's the implication?
Well, the implication is it's not just this Bode George issue. When you look at most of the cases that have been handled by the EFCC, especially those ones that have to do high-profile corruption cases and all that, they've never succeeded in most of these cases. Look at the way and manner the James Ibori case ended up in Asaba. And the case has also collapsed in the UK, even though Ibori pleaded guilty and another. But when it now comes to the confiscation of his assets and another, the prosecutor has found it difficult to prove his case. So at the end of the day, James Ibori may go away with all the loot or with all the stealing he may have alleged to have committed. Now they also took a Rufai to court. That case has also collapsed. A Rufai has been discharged and acquitted. You ask yourself, why will the EFCC take a Rufai to court because he allocated land? Is that within the purview of the EFCC, for example? I continue to answer. So, thank God Mr. GT Ogunye is a litigation lawyer. He goes to court on a daily basis and all that. And we see the performances of most of these EFCC prosecutors in court and all that. And I don't blame them. The issues are very, very complex. Why do I say they are complex? Most of the people who readily avail the prosecutor, the material evidence with which they know the defender, are most times participants, criminals in most of these offenses. Secondly, they are also beneficiary. And when you also look at the Nigerian environment the way it is today and other, we are never too eager to want to testify against people that have been prosecuted for these manners of crime in the side. So the EFCC has a limitation, and the limitation has to do partly to their inefficient in terms of investigation. Because, for example, if you allege that Bode George splitted contract with the intent to defraud or abuse his office, the next logical step you would have taken to say, did he benefit from the split of contract and then the abuse of his other office? And if he benefited, you must be able to lay the ingredient on the table, put the proof of evidence before the judge and look, this is what he did, this is what he benefited, or this is certain persons or individual or corporation that he inherited. That the prosecutor was unable to do. And I think that's where the cross of this matter lies. So if you are going to succeed in the prosecution of corruption cases in this country, it must be an holistic approach. All the Nigerian people must be ready when they are called upon to testify in court. The EFCC must also be charged with the responsibility, with the wherewithal to really be able to conduct very, very thorough investigation before you go to, and then more importantly, the EFCC should stop playing to the gallery in most of this corruption. I give you an insight. Bode George ran into problem when he filed a defamation case against a media house in this country. When he filed that prosecution case and he was pursuing it with a lot of alacrity, then the media house also started digging in his own backyard into his own skeletons and all that. Because they knew if he succeeded in that is defamation case, it is the possibility that he could wind up their business is very, very hard. So they started digging, and then each time the case was going to die and all that, they would publish criminal headlines and all that, so that the EFCC had no option other than to railroad and take Bode George, even when they haven't been able to do a very thorough investigation of whatever allegation may have been made against him by this newspaper. So the lessons to learn from all of this is that the EFCC must not pander to the happenings in the society. I mean, the ulabalu from the media houses. It's one of those things they should look into when allegations are made in this way. It becomes an ingredient for investigation, but it is not the investigation itself. It is not the report that you turn in to the court to use to nail people.
Okay.
Prosecution fails in this country not because investigators and prosecutors are not efficient. There are certain extra proceedings, should permit that license, extrajudicial factors that impact more on proceedings, judicial proceedings, and determine the outcome of trials more than inherent issues in the course of adjudication. Look, the example that my learned friend cited, James Ibori. How did it happen that James Ibori went throughout the entire gambit of the judiciary twice, and the lawyer who was insisting that that was James Ononefe Ibori was no other person than Chief Gani Fayemi, who has set several precedents at the Supreme Court. And the Supreme Court said that no, it's doubtful whether he was the same James Ononefe Ibori. He had no criminal record. And Justice Marcel Awokuleyin of the Federal High Court said that there's not even a prima facie case against him. And yet, that same James Ibori went to England, and when he saw the determination of their judicial system to ensure that justice was done, he started pleading guilty. The difference is the environment, the adjudicatory environment, and that how that environment, operates. Look, when my friend talks about thorough investigation, they should do their job and all that. What has job being got to do with the man who stole a pension scammer to just go home and pay a little, or the judge who told Igbenedon to just pay something and go home? I'm telling you that it has nothing to do with investigation or prosecution. It has to do a lot with judicial disposition, and I've told you that judicial disposition is not something that occurs only because of what judges do. There are a lot of things that go on, and when my friend talks about
I didn't was not disclosed to cases of corruption. That was why the defendants were complaining.
I didn't interject. All right. Now, I can give you 2 examples here.
Okay.
Justice Olubiwoye, who was the trial judge in this case, had handled other cases before. The Brazilian bank case. And eminent lawyers, including Shivoti Williams, Joko Ajayi, appeared before him. And he said, look, justice has to be done. And justice was done. Okay, so it is not about investigation was not correct. And in certain cases, because my learned friend referenced a point, and I was just wondering, do you know that in certain cases, in certain murder cases, even when the corpus delicti could not be found, somebody can still be sentenced to death.
Sure.
Given the circumstantial evidence that is regarded as the best evidence, sometimes. The problem is that since we are all initiates, lawyers here, when you read a judgment, you can read a judgment, and then something occurs to you that
something is fishy.
and you can then read the judgment, and then so we all know it, but this is not to take anything away from lawyers who handle this matter.
The cold letters of the law.
They did their best and all that. But the point is that the implication of this judgment, for me, is that it's put our Supreme Court once more in the eye of the storm. It is not correct to say that lawyers and non-lawyers cannot critique a judgment. Otherwise, case review, will not be fashionable in the legal profession. You can critique a judgment. The thing is that in doing so, you have to maintain decorum, you have to be civil, and you don't have to resort to abuse. Don't abuse judges, but you can critique their judgment. And so I know that after now, many people will still write about this judgment. Many people will analyze this judgment and point out the implications for the fight against corruption. Why is it so common these days for our courts to seem to buckle before the people then start intervening and then start saying, no, you can't do this? And I give you the example of the pension case. Yeah. Everybody, non-lawyer, said that everybody became a lawyer instantly. And of course, the EFCC then went back to court to charge and all that. And on that occasion, the court, before whom the man was charged afresh now, refused bail application. Refused bail application because the court saw that the people were genuinely angry. So the point I'm making is that yes, the Supreme Court is a court of last resort. Once they deliver their judgment as lawyers and non-lawyers, by virtue of Section 287 of the Constitution, their decision is binding on all persons and authority.
All right.
And so we have to accept it. But even while we accept it, we can disagree and say that these are things that we are not happy about.
Okay. Thank you very much, Mr. G.T. Ogunye, for coming on the program. Mr. Tunde Kloawale, thank you for coming on the program. It's a pleasure. Well, thank you so much for letting us be a part of your evening. We still have a few tweets that just came, but I'll just take one. Taiwo Olatunji says the Supreme Court has set a deadly precedent in our judiciary system. Remember, they will be referring to it in court in the future. Thank you so much for letting us be a part of your evening. Till we bring you another edition. Remember, the extant criminal provisions in our criminal law, even though they are dated back to the 50s, they are still effective. That's what the lawyers have both come, at least both of them agreed on that point. And then abuse of office or contract split